Hi friends, today's topic is mistake. Mistake in contract law sections 20, 21 and 22 of the Indian Contract Act deal with the concept of mistake. What is a mistake? A mistake means a wrong belief about something in a contract. When one or both parties do not understand the facts or law correctly, it is a mistake. Types of mistake: bilateral mistake, unilateral mistake, and mistake of law. Bilateral mistake, section 20 says when both parties are mistaken about an important fact, the contract is void, means not valid. For example, A agrees to sell a horse to B, but the horse is already dead and both don't know. The contract is void. Unilateral mistake. Section 22 tells us if only one party makes a mistake, contract is valid, means not void. Example: A wants to sell his old bike for rupees 30,000. B thinks it is a new model bike, but A never said that. B agrees and pays rupees 30,000. Only B made a mistake about the model. A was clear. This is a unilateral mistake. The contract is valid. B cannot cancel it. But exception: if the other party knew about that mistake and took advantage of it, then the contract is not valid. This is called an exemption to the general rule. Why is it an exemption? Because the law wants to be fair. If one person is confused or mistaken and the other person knows about it but says nothing and uses it for their own gain, then the law will protect the person who made the mistake. So that contract will be cancelled or declared invalid. Example of exception: A is a farmer. His land is 2 acres. B is a land buyer. B checks and knows the land is only 1 acre, but he says nothing. They make a deal. A agrees to sell the land for rupees 20 lakhs, thinking it is 2 acres. B agrees, knowing it is only 1 acre. The sale is done. Later, A finds out the truth. His land is only 1 acre. He says, I was mistaken. I thought it was 2 acres. Now the law says, because B knew the truth and kept silent, he took advantage of A's mistake. So A can cancel the contract. This is called an unilateral mistake with knowledge of the other party. So contract is voidable by A. Mistake of law. Section 21 explains the concept of mistake of law. Definition of mistake of law. A mistake of law occurs when a person enters into a contract under a wrong belief about what the law actually is. Important point is ignorance of law is not an excuse. This means if someone did not know the law or misunderstood it, the contract still remain valid. You cannot cancel it just because you did not understand the law. Legal point. A contract is not voidable because it was caused by a mistake. As to any law enforced in India, no excuse for misunderstanding it. Contract is valid even if based on mistaken understanding of Indian law. Only mistake of foreign law is treated like a mistake of fact, which may make contract void. Example: mistake of law in India: A agrees to sell land to B, thinking that agricultural land can be freely sold without government permission, but actually government permission is required. A cannot cancel the contract, later saying, "I did not know the law." The contract remains valid. Mistake of foreign law. Section 21 says mistake of foreign law is treated as a mistake of fact. The contract can be void if both parties misunderstood. If you like to learn law in an easy way, please like, share, and subscribe to my channel. Let the light of law reach everyone. Thank you.